Probate. So today's topic is about probate. So probate is a legal process that occurs when a person dies in the state of California, and two things happen. One of those things is when they own real property that's not titled in a trust. And then the other thing that happens is if they have cash assets that are titled in their individual name that doesn't have a beneficiary attached to them, that when you add those cash assets without a beneficiary together, their total aggregate value exceeds $184,500. And I like to refer to that as what I call a magic number. So every state in the United States has this magic number that when a person dies, if they have assets in their name that doesn't have a beneficiary attached to it, you have, if those amount of assets exceeds this magic number, then that state deems those assets to be so valuable that they want the courts involved to make sure that those assets go to the right people. So my dad lives in Rhode Island, and in that state, the magic number a couple of years ago when I last checked was $15,000, which is unusually low. And in California, our magic number used to be $150,000, and then it went up to $160,000. And now today it's worked its way up to $184,500. So just for example purposes, what that would look like is if I had a bank account and if I had $100,000 in a checking account titled in my name that didn't have a beneficiary attached to it, and let's say I had a CD account in my name that also didn't have a beneficiary attached to it that had $200,000 in it, because when you add those two accounts together, they are $300,000 in total value, and that exceeds the magic number, that those two assets would trigger probate in the state of California. But an alternative example would be, in that same hypothetical, if I had a checking account titled in my name with $1 billion in it, and if I named my husband as the pay on death beneficiary, then that asset would not have to go through probate as long as my husband survived me. But alternatively, if I had the same bank account with $1 billion in it, and if I named my husband as the pay on death beneficiary, but if he predeceased me, and if I didn't have a living beneficiary named as a secondary beneficiary to inherit that account, now that asset would trigger probate. So those are the two things in the state of California that takes us into probate when a person dies. And that's part of why so many people, have trusts. And that's because if you own real property, no matter how much your equitable interest is in real property, just owning real estate, if it's not titled in a trust at the time of your death, that will take us into probate. So I have a trust and our house is titled in our trust. But sometimes what happens with real property is when people refinance their house, unbeknownst to them, a mortgage lender can take the house out of the trust during the refi. And if when my husband and I pass away, even with a perfectly up-to-date trust, if our house is not titled in the name of the trust at the time of the surviving spouse's death, then that house will trigger probate even though we have a trust. So that's a really important thing to understand, is that even if you have a trust, you can still go through probate in California. And then sometimes people will call. I had a lady call me one time, which was totally fair. And she said, Heidi, I'm a single woman. I have an adult daughter. She's so financially astute with money that I have put her on title to my property, and we're joint tenants with right to survivorship. And what that means is, if she predeceased her daughter, which she said in the natural scheme of things, I'm hoping I go first, as joint tenants, you avoid probate because there's a surviving owner attached to that house. And she said, what I've done is I've also added my daughter onto title of all of my bank accounts. So that way, when I die, I don't need a trust, because as long as my daughter survives me, all of my accounts by operation of law will avoid probate. And therefore, I don't need a trust or an estate plan because everything goes to my daughter. So why do I need a trust? And I said, well, you know, that's pretty good logic, except that, is your daughter married? And she said, yes, she is. And I said, do you like your daughter's spouse? And she kind of hesitated. And I said, have you given any thought to the fact that if your daughter's marriage sadly fell apart, chances are her ex-spouse, through the attorney, is likely going to try to make the argument that part of your assets are the spouse's through community property. And she said, no, I never thought about that. And I said, well, that's one risk of having your daughter entitled to your assets, is if her and her spouse got a divorce, there's likely going to be made an argument that your daughter's former spouse is going to try to claim that 25% of your assets is theirs through that divorce. And that's going to be a problem. I said, and the other problem with co-ownership of assets with somebody who's really not an owner is if your daughter sadly was in an accident, whether it's a car accident or if she had any other kind of personal liability, whether it's bankruptcy, then your assets are also lienable by her creditors because now she has personal liability. And she says, well, I never even thought about that. And I said, well, that's one reason where having those assets titled in a trust can protect you, because when you create a trust and when assets are titled in a trust, not only do they avoid probate, which negates the need for the joint tenancy, but you name a person called a successor trustee in a trust, and that person is a manager of your assets, not a co-owner of your assets, which alleviates the problem of joint tenancy. And then the other problem, if you don't mind me just giving a little more information, is when you add an adult child or any person to your assets while you're living, because that's a lifetime gift, they don't get what's called a forgiveness of capital gain. Whereas if I give my loved ones my assets after I die, all of the capital gain with those assets is fully forgiven. So for example, my grandparents, when they passed away, the house that they bought in Point Loma, they paid like $35,000 for. And by the time my grandmother had passed away, that house had appreciated to over $1 million when they had passed in the early 2000s. So when that house was sold, all that capital gain from their original tax basis of $35,000 to the final amount of appreciation, which was over $1 million, was forgiven, because when they bought the house at $35,000, well, my grandfather, who was the first spouse to die, at his death, there was a full forgiveness of capital gain. So if my grandmother wanted to downsize or move or relocate, she could have sold the house because there was a full forgiveness of capital gain at his death. And then when she passed away, because she was still living in the house at the time of her death, now the house was worth even more money. And when her kids, my mom and her siblings, inherited the house, all that additional capital gain was also forgiven. But in the example I just mentioned of the single woman who added her adult daughter onto title of her house, you don't get a full forgiveness of capital gain when you make that lifetime gift of real property, because it's a lifetime gift versus those assets being inherited at death. Plus, you also have a gift tax issue, because we can only gift so much money per year, which in 2025 is $19,000 per person. So you have to report that excess gift on your state and federal income taxes. So my point being, it's not a good idea in general to add people on title to your assets to avoid probate. It's usually better just to have your legal affairs in order to avoid probate. And generally speaking, having a trust is one option, or having pay on death beneficiaries is another option. And I see a question in the chat. Will you be discussing TOD deeds for real property? Yeah, in fact, let's talk about that right now. So I'll be honest, David, I'm not a big fan of TOD deeds, but I might be in the minority, but I'll explain my reason. So there's a new thing that's, well, it's relatively new. It's called a transfer on death deed. I prefer quitclaim deeds transferring real property into trust. But what a TOD deed is it's a transfer on death deed. So actually, let me kind of back up a little bit. So let's start at the basic. If I'm a single person and I own a house, I, as an attorney, prefer to put that house into a trust because real property in a trust will always avoid probate. My preference for a trust is this. In a trust, you can identify a primary beneficiary, a secondary beneficiary, a third beneficiary, etc. My issue with the TOD deed is you identify one beneficiary. So what happens then if, let's say hypothetically that I'm a single person and I have one child, and let's say that my one child and I are hit by a drunk driver and we're both killed simultaneously. Now I have a TOD deed that's going to go through probate because me and that one beneficiary are both deceased. So for that reason, I'm not a big proponent of a TOD deed because to me it's not foolproof. Whereas when you have a house and a trust is always going to have so many layers of beneficiaries, and a house and a trust never triggers probate. But when you have a TOD deed, if that beneficiary attached to the deed is not surviving you, now we have a probate. And then the other reason I'm not a big proponent of a TOD deed is when each of us pass away, your executor or trustee, their primary job as your fiduciary is to pay all of your final debts, bills, and taxes. But if you have your assets TOD, which means transferring on death directly to a beneficiary, now we don't have a bucket of money available to your executor or trustee to pay your final debts, bills, and taxes. And that's a real problem because under California state law, legally your beneficiaries aren't supposed to inherit your assets until all your debts, bills, and taxes and creditors have been paid in full. But if we TOD and transfer on death directly to beneficiaries, how is your trustee and executor supposed to meet their fiduciary duty of paying those final bills and satisfy that duty when there's no monies available paying into the estate or paying into the trust if all of those monies are paying directly to people? So I like to have assets paying into an estate or paying into a trust so there's liquidity available first, so that your executor and trustee can satisfy that due diligence of paying all those debts, which is required by law. And then they take the excess and pay those monies to the beneficiaries. So that's just my opinion, but I can tell you I have colleagues that will disagree with me, which is totally fine. I'm a big proponent of people having different opinions because I think that's what makes our country great. And then there's another question that says, if my son's divorce precedes my death, does his ex-wife still have a claim? That's a great question. So I want you to know that California has a bias against daughter-in-laws, son-in-laws, and non-blood relatives. So typically in an estate plan, whether it's a will or a trust, when we write distributions to beneficiaries, it is presumed that we're going down the bloodline, which is biological and legally adopted, but never step. And that also applies to spouses. So if I were to predecease, if I was a named beneficiary, and if I predeceased the person who was naming me as a beneficiary, my husband is never going to be an implied beneficiary as my spouse unless he's identified by name. So if so it says, what if my son's divorce precedes my death? Your son, even if he was legally married at the time of your death, your daughter-in-law, with all due respect, would have no rights to your estate, just so you know. So, and one of the things I always ask my clients, which not all attorneys do, but I do, and not all people choose to put this in their estate plan because it is an optional clause, is you can put a provision in your estate plan that requires your beneficiary prior to inheriting this money, if they are married, to put this money into their own separate account. Because in California is a community property state, which means from the date of marriage going forward, 50 cents of every dollar you make is each other's. But an exception to that is an inheritance. So when a person inherits, that is their sole and separate property. And one benefit of keeping assets separate is if my husband inherited money from his mom, hypothetically, and I'll make myself the bad guy in this example. And let's say I was texting and driving and I was reckless and I was in a car accident and now I have creditors coming after me. All of our community property is reachable by my creditors, but his separate property that he inherited is one bucket of money that's protected. So one benefit for a married couple of keeping separate properties separate is that is one way for a married couple to have a bucket of money that's protected. And that actually benefits both people, not just that person. And the other benefit naturally is if that couple were to get a divorce, sadly, inherited monies, gifted monies, or assets that you owned prior to marriage that you kept separate property is not part of a divorce. So that's part of why I ask my clients in doing their estate plan, do you want to include a provision that a married person has to inherit these monies in their own separate account? And the way that works is if a beneficiary is married, they would have to create their own separate account, and that trustee would make that distribution payable to that beneficiary's separate account. And the benefit of that is most married couples don't always understand our very complicated community property, separate property laws. And what can happen is in California, if I'm a married person and if I inherit monies and put it into a joint account, whether I intended to or not, once that deposit of inherited separate property monies goes into a jointly titled community property account, whether I intended to or not, I've just made that community property and it's now 50-50. So when you include this provision about requiring inherited monies going into a separate account, that money's protected. But once the monies are deposited into that beneficiary's account, now that beneficiary owns the money and legally they can do with that money whatever they choose to. So if they want to take some of the money out and buy their spouse a car, or if they want to take some of the money out and put a new roof on the community property house, they can share some or all of that money with their spouse if they choose to. But if they find out that their spouse has been cheating on them with their best friend, then they'll be happy that they kept that money in their separate account because whatever's left in that account is protected from that divorce. So one nice thing about doing a trust is you can put contingencies in place that apply to beneficiaries as they're inheriting the money. And so that is one of the nice things about, I mean, there's a lot of good things about doing estate planning, but that's one of the many nice things is you can put contingencies in place as to how assets are being inherited by your loved ones. And something like that, I think, is a good thing, because when you make a beneficiary jump through the hoop of creating a separate account, now they have the understanding that this is separate property and there's a reason why I'm keeping this money separate. And sometimes that's a very good thing to teach people. So when we have probate is a process in California that occurs when we die and we have real property not titled in a trust, or we have over that magic number. And there's three things about probate that aren't desirable. One is it's a public process. So anybody can go to the San Diego probate court, pull your file. And part of what you're not going to like about probate is you and your loved one's date of birth, social security number, and most recent address is all public information. So anybody can go pull your file and find out all that information about you and all the people you love. And in today's world of identity theft, that's really unfortunate because these are old laws. And back in the day, that didn't happen. But in today's world, that's really unfortunate. The other thing about probate that is unfortunate is under California law, a probate from beginning to end has to be open for a minimum of 6 months. But the reality is we only have 3 sitting probate judges in San Diego County. So the reality is most probates from start to finish take about a year to complete. And then the worst part of probate are the fees. And that is because the fees are statutory. And that's a fancy way of saying they're predetermined by law. And there's a handout that we emailed to all of you about estate planning. And I'm pretty sure that those probate fees are at the back of the handout. If you give those a look, The probate fees in California are probably some of the highest probate fees in the United States. On average, the lowest a probate fee can be is $7,100. The average probate fee that we see is usually anywhere from $25,000 to around $50,000, which is a lot of money. And the sad thing about that is it's a statutory fee. So when we do probates, we're not necessarily getting paid for how much time we're putting in. We're getting paid for a percentage of the assets. So the nice thing about probate is it's totally avoidable, but you just have to know how to avoid it. So that's what we're talking about today. Okay, so there's another question about the TOD deeds. Oh, okay. So that was just a little comment. Oh, there's another question about the question about my mother's trust where it mentions me and not my spouse. Is it sufficient for me to place those into my own account? The answer is yes, because I'm assuming that's what your mom wanted, was for you to inherit those assets and not for those assets to go to your spouse. That's pretty common. So when you have, so for those of you who have an estate plan, typically what's going to happen is your attorney's going to want to know whether you want to do a trust or if you just want to do a will. And it's usually going to come down to what assets do you have. When you own real property, you always want real property titled in a trust, because if you own real property and if it's not titled in a trust, that's always going to trigger probate. And for those of you who took advantage of the recent low interest rates, you might want to look at your property tax statement, because your property tax statement is always going to show how your house is titled. And you always want to make sure that your house is titled in your trust, because that's how you know that it's not going to trigger probate. And if any of you have a trust and if your house isn't titled in your trust, you absolutely want to have a deed prepared that puts the house into the trust, because real property going through probate is the most expensive probate. And then the other thing is if you don't own real property, you may or may not need a trust. And the question there is, who are your beneficiaries? So I have two minor children, so I need a trust, because even if I didn't own real property, I can't give my assets to minor children without a probate needing to be established, because minor children can't inherit money. But if my children were adults and if they were of an age and maturity that I was comfortable just giving all my estate to my children today, then I may not need a trust, because I could just name my children as a pay on death beneficiary. So sometimes people who have large estates that exceed that magic number may not necessarily have to do a trust, because they could just name their kids as their pay on death beneficiary. But then the tricky thing becomes, one of the things attorneys always ask their clients is, who's your contingent beneficiary? Meaning, if either of my children predeceased me, if their share is going to go on to the grandchildren as a contingent beneficiary, and if the grandkids are younger, maybe 9 and 10, then again, you're back to needing a trust, because you can't have minors inheriting money without it having to have a guardianship through the courts. So oftentimes trusts are also needed when you have younger beneficiaries inheriting, to keep the courts out of, managing monies for the benefit of minors. Plus, as I mentioned earlier, it's always good to have those monies in the trust so that the trustee has monies available to pay all your final bills and do the trust administration. So when you create the trust, it's really important when that trust is created that you put your taxable assets into the trust, or name the trust as the pay on death beneficiary. And your taxable assets include your life insurance, your checking accounts, your savings accounts, your investment accounts, your CD accounts, money market accounts, the real property, timeshares, the corporate interests, if you own an LLC, an S Corp, a C Corp. The only kind of an asset that should not go into the trust for tax reasons are annuities, where you should name individuals as beneficiaries, and retirement assets, where you should also name individuals as beneficiaries. So one big change in the law for those of you who might have set up your estate plan 10 years ago or earlier, it used to be 10 years ago when the laws were different, You could name your spouse as your primary beneficiary for those of you that are married, and you would name your trust as the secondary beneficiary. But now you no longer want your trust as a beneficiary on your retirement accounts because naming the trust creates unnecessary taxes. So if you haven't reviewed your beneficiaries on your retirement assets in a while, I would encourage you to log in and review who your beneficiaries are on your 403Bs, your 401Ks, Roth, IRAs, SEP simples. You always want to make sure that you have people, charities, but not the trust named as a beneficiary because that triggers unnecessary taxes. So retirement assets are always going to pay directly to individuals or charities, alumni, whoever you decide to name, but not pay through the trust. And then what happens is when each of us pass away, as long as you have the real property in the trust, as long as those taxable assets named the trust or pay on your death through the trust, and as long as you have living beneficiaries on the retirement assets, then we should avoid probate altogether. And then the next question is, if we have to go through probate, then what happens is when we die, your durable power of attorney and your healthcare directive die with us. And all we have now is your trust and your will. Those are the two documents that exist at the time of your death. And if we have real property or if we've exceeded the magic number, if we have real property that's not titled in the trust, which is what I meant to say, or if we have assets titled in our individual name that exceed the magic number that will trigger probate, then the next step is we have to petition the court and we have to get appointed as the executor to start that probate process. It generally is a good idea to hire legal counsel if you are going to start a probate because probate is a legal process. If you are going through probate, you will get paid for your time. The attorney gets paid for their time, and that's part of why it's so expensive, is because those statutory fees get paid twice. But they do get paid from the estate. And if there isn't a will or a trust, then a person can die what's called intestate. When a person dies intestate, that means that the state of California has decided who the beneficiaries are. And legally, the intestate statute will have a person's assets going to their closest living biological blood relative. So if I died without a will or a trust, the intestate statute would give my estate to my spouse first if I'm legally married. And there is no common law in the state of California. So if I die without a legal spouse, if I've been living with somebody for 15 years, calling them a spouse, that legally does not count. And if I die as a single person, then my estate is going to go down my bloodline to my legally adopted and biological children, but not step. And if I have no living lineal descendants, heirs at law then goes to my parents, which is my mom and dad, but not step. And then it would go sideways to my brothers and sisters, which includes half siblings, but not step. And then any sibling who predeceases me, their share would go down their bloodline to my nieces, nephews, great nieces, great nephews, which also includes, which does not include step. And then if we still haven't found a biological relative, we go up the bloodline to grandparents, aunts, uncles, first cousins, second cousins. So that's what happens when a person dies without an estate plan. They die intestate. And then a person would have to petition the court to start a probate, and they're called an administrator. So an administrator is the title of a person who's starting a probate when there is no will or trust. An executor is the person when there is a will. And then when you start the probate process, you have to file a petition, and that's how the whole probate process starts. And basically what you're doing on the petition is you're asking the court to appoint you, and within the petition you're identifying to the court who the closest living relatives are of the decedent, and you're also disclosing all the known assets and debts of the decedent. And then once you've had your hearing and the court has approved you, and at that hearing, if anybody has any objections to you being appointed, They do have the ability to also appear and to object, which sometimes does happen. Then once you are appointed by the court gives you something called letters testamentary. And it's the letters testamentary that the financial institutions will recognize that gives you the ability, while these assets are under the jurisdiction of the court, to manage those assets. So remember, the probate has to be open for a minimum of the 6 months, but usually this whole process is going to take about a year. So during this process, the executor does have the ability to sell assets. So if we have real property before the probate court, and if the executor has talked to the other beneficiaries, and if the executor knows that nobody wants the real property, during the probate, they do have the ability to talk to the beneficiaries and see if anybody wants the real property. And if nobody does, they can list the real property for sale. But the net sale proceeds from the real property has to be deposited into an account that it's under the jurisdiction of the probate court. Because while the probate is open, all those assets before the probate are basically frozen because everything's under the jurisdiction of the probate court. And then the next thing that the executor does is they prepare a document called an accounting. And the purpose of the accounting is the executor is going to basically account to the court that they've done their due diligence of paying all the decedent's debts. They've met with the CPA, they've audited the decedent's social security number, they've brought any back taxes current, they've paid the current taxes. You do a preliminary accounting at the beginning of the probate, and then you do a final accounting towards the end of the probate. And then basically after that 6 months period has told and you've filed that final accounting, you've paid the bills, you've paid the final taxes, you've sold any assets that the beneficiaries don't want, then you have that final court hearing where you've basically account to the court, they've approved your final petition, they've approved the final accounting. And as I'm saying all this, I'm saying it so quickly and easily, but all of this takes hours and hours and hours of work. Then once the judge approves all of that, then the court will give you final court order. And then that is when the assets are unlocked from the court. And that is when the executor has the court's actual legal permission to change the title of those assets into the beneficiaries' names. And then that is when the beneficiaries will take legal ownership of those assets. And that's when the probate is actually over. And it's not until the end of the probate that the executor is entitled to be compensated, which they pay taxes on. And that's when the attorney gets paid. And then that is when the full process is over, which again, I said all of that in about a minute's time, but that is like a whole year's worth of work that takes a lot of time and a lot of hours. And now I see questions over here, which is great. So it says, should the IRS form 1041 be filed when the trust is created or when the trustor passes away? Usually the taxes are all handled after the person passes away. And I would always, when a person passes away, one of the first things you're going to do is you're going to want to talk to either their CPA, if you know who their CPA is, or you'll want to talk to your CPA, because the tax part of it, usually there's not federal estate taxes, but there could be state and federal income taxes to deal with. So when a person dies, there's something called federal estate taxes. That's the amount of money that the federal government allows each of us to leave tax-free. That amount of money changes every year. So right now, this year, each of us can leave over $13 million federal estate tax-free, which is a lot. They were talking about taking that down to 5 million, but luckily they didn't. So, and if you're married, each spouse, it's like it was 13.62 million last year, and then this year it jumped up. It's just under $14 million per person this year. So as a married couple, you can leave almost $28 million tax-free together. And then every year, each of us can gift a certain amount of money, gift tax-free per person. Last year it was 18,000. This year it's 19,000. And then when we die, if you gift assets after death, all the capital gain is forgiven. So it's usually a good idea when it comes to real property that you want to gift that asset to loved ones after you pass away versus gifting it while you're living for all the reasons we talked about. And then property taxes is also something to consider when it comes to real property. Prop 19 did change Prop 13. It used to be under Prop 13 that if I'm your parent and you're my child, I could gift you 10 properties. And because it was a parent-child transfer, you would keep my property tax basis on all those properties. But now under Prop 19, you're only going to keep my property tax basis on my primary residence. So if I give you 10 properties, those 9 other properties are going to be reassessed because you're only going to be able to keep the property taxes on my primary residence. And here's another yucky. You're only going to keep the property tax basis on my primary residence if you move into it and make it your primary residence. So Prop 19 unfortunately changed Prop 13. It pretty much gutted it. The Realtor Association lobbied for that proposition because they wanted, when people died, for people to sell real property, because it used to be people didn't. They kept it and kept it in the family. But now because of Prop 19, people are selling real estate when people die. So the realtors got their wish, which I get it. I'm not trying to be on one side or the other. I get both sides of it, but Prop 13 used to be such a great thing. And now, unfortunately, Prop 19 pretty much took Prop 13 away from all of us, which is unfortunate. And then here's another question. It says, am I responsible for my husband's debts at his death if he incurred them before we were married? Well, that's a good question. I mean, technically, a person's assets and debts before marriage would be deemed separate property, but it's just a matter of how do you prove it was their separate property. I mean, student loans are a type of debt that are always the separate property of the person who incurred it. So some of it would depend on the type of debt that you're speaking of. But that's something that maybe you just try to keep a paper trail and keep all of that separate. But sometimes, depending on the type of debt, not always. I know that when my aunt passed away, she sadly had a gambling habit that her husband didn't know about, and she had a credit card with like $35,000 from the casinos on it. But because that was incurred while she was married to my uncle, he had to pay all of that debt. So that's some tricky stuff. But usually the assets and debts before marriage are the assets and debts of that person. But when a person dies, you are liable for administering their estate. So when that happens, I would maybe just contact those creditors and tell them that that was their separate debt. And if they give you push, then maybe just push back twice as hard, because I think you do have a good legal argument there. And then it says, how do we deal with assets and banking accounts outside of the United States? That's a really good question. So the United States does not have jurisdiction outside of its borders. So a United States estate plan cannot hold assets within it that are outside of its borders. So for my clients that have assets outside of its borders, I have to tell them that they have to deal with those assets in that other country. So some of my clients have 2 concurrent estate plans. They'll have one in the US and they'll have one in Spain, or they'll have one in the US and one in Mexico. So because the US has no jurisdiction outside of its borders, if you have assets in another country, you do need to talk to an attorney in that other country to find out how you have to deal with those assets there. I did have one client, ironically, who had a home in the Cayman Islands. And that attorney said, just list this property on your US trust, which I was really reluctant to do. And I did so reluctantly and did my CYA letter just to make sure everything was okay. And ironically, that kept that asset out of probate there, which really surprised me. But he did talk to an attorney there, and on that attorney's advice, we did what they said, but that worked out. But overall, most countries have their own very specific laws. But it just depends on the country. So you definitely want to get advice in whatever country where those assets are located. Do you guys have any other questions? Because I mean, I pretty much covered everything that I wanted to cover. I know the presentations or the handouts, Vanya, thank you so much for posting. Those are posted there. Hopefully you find those helpful. There's one about estate planning. There's the other one that shows you those. I mean, if you have a minute to look at those probate calculation fees, you'll really be disgusted how expensive probate is. It's really unfortunate it's so expensive. How does probate work if the deceased person has no assets? Well, that's a great question. I mean, really, if a person has no assets, then there should not be a probate needed. But I did have a call one time by a lady who a guy had just bought a house. That was when you could buy a house kind of without having to prove that you had money. And the poor guy was in a motorcycle accident, and the motorcycle was the only asset of value. But he had a huge credit card debt and student loans. And she basically called saying, what do I do? But because the debts exceeded the assets, I said, honestly, if I were you, I would just walk away because there was really nothing to administer. So sometimes when the debts exceed the assets, there's really nothing legally that you need to do unless you're wanting to. There is a hierarchy under the law when debts exceed the assets as far as who's entitled to payment. So it's just a matter of if you want to get involved and be a good person and pay with whatever monies are there, the creditors that are at the top of the list, which you can imagine it's like the IRS is first and things like that. But there is a hierarchy of payment when the debts exceed the assets. But legally, if you do decide to be a good Samaritan and step in and do that, you're never personally liable for the debts of another person when you're acting in these roles, because your role is just administrator. You're not personally guaranteeing the debt of a loved one. Oh, okay. Phone number for our phone number here is 858-450-0505. I think it's also, oh, that wasn't on. I tried doing it to everybody. Here we go. So yeah, our phone number should be on those handouts. We're also with ARAG if you guys have the ARAG legal insurance, if you guys want any estate planning information. But I hope that you found this helpful and educational. I mean, probate is definitely not an ideal process. Other states, probate is super simple, easy. You're in and you're out. It's not difficult. It's not as expensive. Phone number is 858-450-0505. But unfortunately, California probate here, you really want to avoid it. Our probate is pretty antiquated, and because the fees are statutory and real property so valuable, because it's a percentage of the asset, our probate fees are on the high side, mainly because our real estate is so valuable. And that's why in California, you really just want to avoid probate at all costs. Okay, well, I think that's it. So thanks you guys. I hope that was a good use of your time. Do we call your office or ARAG? So you can call ARAG for a case assist because that's how we bill your ARAG, and you can call our office for an appointment. But ARAG's great. That's a great legal insurance that you guys get to use.
Thank you so much, Heidi. This is very helpful.
Thank you. Have a great day, you guys.
Goodbye.